Hey, you have Patrick Findaro, managing partner at Visa Franchise. Excited to have on the CEO of OnlineVisas, Jon Velie, an esteemed immigration attorney practicing for over 2 decades now. And today's conversation, we're going to focus on how you can switch from a non-immigrant visa, or it could be OPT status as a student, to a permanent residence through through one of the green card categories. So, Jon, thanks so much for joining.
Thanks, Patrick. It's a pleasure to be here.
So, we were talking offline before we started that Visa Franchise main focus, E2 visas. That's our bread and butter, what we've been doing for 90% of our clients. We've had clients also do the L1, EB1C, EB5.
Yeah.
We're starting to craft solutions to help people also secure employment in the United States with whatever visa category you think is best for them.
Yeah.
But I'd like to just maybe talk about or open it up, I don't know, at a high level, just U.S. immigration in terms of what the permanent residence options are for these professionals, whether they're an investor on an E2 visa or student on an OPT and they have a science background, STEM background. What are some ways that they can stay here because they don't want to go back and they don't want to have that worry? Because I've had a client with 400 properties under management on an E2 visa, making a lot of money, but didn't have a green card, and was still always a nagging issue and something in the back of his mind, and especially his wife's mind, on when he could get the green card for his family.
Well, thank you, Patrick. I love the opportunity to talk about this. And E2s are interesting because they're not as clean of a pathway as some visas to green cards or permanent residence, right? Or immigrant visas. These are all the same term. Immigrant visa, green card, permanent resident, all means the same thing. Immigrants are actually legal. There's no such thing as an illegal immigrant, right? Immigrant means you have a green card. Non-immigrants are people that have temporary visas. E2s are temporary visas, H-1Bs, and others of that like, right? OPTs are off of the F-1. Those are all non-immigrants, right? And so how to get from a non-immigrant visa to an immigrant visa is really the question in front of us. But I want to start with the E2 because it has some pathways. And some of those pathways can be strategized at the beginning before they get the E2 and say, okay, we're going to take you through the E2, but here's where you're going to go. That's not a bad way to look at it, right? We love to help people plan out where their lives could be from the first time we talk about them, even if they're not thinking about it yet. Just so, okay, if I do this, what will work? Had an E2 conversation today with one of my clients, and it was fascinating. They were in the United States when COVID hit. They didn't want to leave. When we're talking to E2 clients, there's 2 ways to process their visas. One is through USCIS with a change of status. That means, say they're on a B visa, or they're Canadians that are allowed to come down on the equivalent of a B visa. They can then change after they've been here long enough to change their intent from going back, which under the Trump administration and going forward was 90 days. Prior to that, it was 60, right? So they could come down on a B visa, look around, decide if they want to open a company, incorporate that company, and then go to the E visa. What we often suggest they do is, although it's not a legal requirement to rent a space, we think it's a big indicator of viability. Rent a space, hire employees, actually provide goods and services before you're going to put it to one of the adjudicating bodies to determine. Now, I say one of the adjudicating bodies, the 2 options are USCIS, change from the B visa to the E2. The other is through the consulate, and the consulate processing we often suggest to our clients to do, because if you do the change of status in the United States, you're fine if you never leave the United States. But once you do, you have to consular process it. And different than the other non-immigrant visas, E2s are re-adjudicated at the consulates. And depending on the consulate, they may want you to send the package up first, in which they will then send you back questions and then interview your client. And others, they want the client to come in, give the package, and then ask the questions of the client. In either of those cases, it takes a lot longer than the typical non-immigrant visa, say like an H-1B. You go up, your USCIS has adjudicated it. State Department through the consulate gets to re-adjudicate it, but they very seldomly do. They're more worried, is this a terrorist, or has this person been out of status? But they're not going to look at the case from start to finish the way they do on the E2. And they have very specialized E2 adjudicators, as you know, at the consulates on that. Okay, so in this case, the clients came back down and are like, God, that was a headache getting back through the border. When can we go to a green card? So in this client, I did talk to you about strategies of other visas at the beginning, and the other one was the L1. And I often link those together, right? So, I know, but maybe your listeners don't know all of this, but I'll quickly go through the difference. So an E2 is where you invest into a U.S. company in which you need to have 50% of the ownership as a minimum. And there is some thresholds of how much that needs to be or should be, right? So there's no regulation. It says a substantial amount. So, USCIS seems to think that might be okay at 50,000. State Department thinks it's 100,000. Neither one of those are written in stone, and you can probably talk them down a little bit, but best practices is to understand what those thresholds are and get above it so that you're not stuck at a consulate trying to talk them into 80,000 is sufficient when 100,000 would have done it, and you've gone that.
Time is money. It could
time
take
is
like
money,
an extra
right?
3 months. You're going back and forth. You can't get your kids in school in August because now it's
100% of a headache, right? So it's good to tell them where the out of bounds lines are, what's black and white and what's gray. So black and white is 50%. Gray is how much money, but 100%, 100,000 is above the line. So we often suggest our clients do that. It's also, you should have some employees and they should already be hired before going in. Immigration will not approve an idea, right? So you need to have something working. And that's why when they came down on the B1, B2 was a great way to get their company going. Now, they had a company in Canada that has done very well. 25 employees, makes a lot of money. It's something to do with, a gym of some sort. So, but they didn't want to set up a sufficiently large enough company in the United States, right? And so for an L to work, you need to have 3 tiers of employees, right? That's the executive tier, the manager tier, and the frontline workers, right? So what I think the minimum number is 5. That's 1 executive, 1 manager, and 3 workers. Any less than 3 workers, you don't really need a manager. You don't need the manager to look over the 1 employee to tell the executive what it is, right? So you need to have that enough girth or substance in the company to do it. And they didn't want to hire that many employees prior to getting the visa, was the honest thing of it. Well, the cool thing is that, okay, you could still do the EB1-3 green card, which is the green card version of the L1. Now, in that, you have to have worked for the company outside the United States for one of the last 3 years. Now, what's really interesting is that's told under the L visa, and I had to go do some research sometime after that, not for this case, but a while ago. Was that limited to the L? And it isn't, right? So you could be on the E visa if the relationship with the company was structured correctly. So we knew that they might want to go to the EB1-3 visa in the future. So we made sure that the relationship wasn't just her individually putting the money in the American company, but having her Canadian company put it into the American company. And that made the Canadian company the parent. So there's a parent subsidiary relationship, and it can either be a parent subsidiary relationship. That's where one company has control of the other. Now that's typically 50% or more, but in really big companies or public companies, no way a company would own 50%, but they'd have control because they're on the board or maybe leading the board or even a board seat. All right. So that's how you get to that. Now so they had that, and she had worked there of one of the last 3 years, and we structured it that way. So that,
how do you define what this has come up quite a few times where like I talked to an Indian national living in the US. He's on the board of his father's company in India. Does that count? Like what counts as work to meet that EB1C criteria?
Excellent question, because that's not where I was putting that. The board, what I was talking about is a big company that you could have control on the board, not the executive position. That's a separate question, but it's really easy to confuse that. So what I said is because she had more than 50%, matter of fact, she had 100%. So her company in Canada, 100% owner of her company in the United States. The other thing besides parent subsidiary is affiliate, meaning the same companies, the 2 companies are owned by the same individuals or enterprises in the same amounts, right? So if you have 2 owners in Canada, 50-50, you have to have the same 2 owners in the United States to have the affiliate relationship. Okay, so that's the nexus in the company. Then it's a requirement to have been an executive or a manager in Canada, and that you will be coming to be an executive or a manager in the United States. Now, you don't have to be in the same position. You can be an executive in Canada and a manager in the United States. That happens all the time. American company buys a Canadian company. The guy was the CEO of that company. We're going to bring him in as a manager of something, right? He's not going to be the executive. All right. So what makes an employee is really critical to the question you just asked. A board member by itself is not an employee. Just isn't. It's not a job. You don't get a salary for that, right? You're in an impressive role, but there are duties that you have to meet. So an executive has job duties, and you have to prove that they had those job duties. You usually have a contract. Sometimes the contract lays that out, but you would have a superior employee talk about what those were. Now, if it's a CEO, you have to have somebody that's inferior, but sometimes you can use a board member or something there. But what are the duties, right? So an executive duty, or they're going to oversee things. They're going to have executive meetings. They're going to have subordinate managerial employees underneath them. They're going to carry out what they do. And managers, one step below that, they're going to either oversee people and usually should have to have at least one supervisory employee with them as well. That's a regular manager. There's a thing called a functional manager. Think of a function as an area. So let's take the example of the guy that was a CEO in Canada. Let's say he was moved into R&D, okay? And R&D consists of one guy, and he's going to keep inventing the kind of stuff he did in the company in Canada. But he has a budget. He is on a dotted line with other supervisors. So when he invents his widget, he sends it over to the marketing and sales team that, do things with it and then sell it and things like that. That's a functional manager. You got to prove a lot why that's functional, such as having a budget and discretion and proof of those things. But you can get there on that. So to go back to your question, and I'm sorry I took the long way around to get there.
No, I appreciate it. You dropped a lot of nuggets that are
helpful
for me, and I'm sure a lot of people listening.
Yeah, there's nuggets, right? You want to, that I resonate with that. Yeah, so a board member is passive and it doesn't work, has to have an executive role. Now, you can be an owner. You can be an owner as long as it's an executive role, right? So if you're the owner and you do everything, that's great, even if you don't get paid a salary. But if you're an owner and you have a profitable company and you're not taking the profits, that's a question mark. Because at the end of the day, with all these cases, is it real, right? Or are they making it up? Here's a letter saying you're the owner, but you've never taken any money of this $5 million company. What owner wouldn't take money from his company? Some owners may not take a salary, but they'd always take money.
And they do site checks. I don't know how often, but I remember we had a Brazilian client try to do the L1, and we didn't know, but he falsified how many employees that he had in Brazil, and it wasn't as big of an operation. And I was caught off guard. The attorney was caught off guard, and he did not get the L1 visa, rightfully so.
Well, I haven't heard them do site visits overseas. Not that they couldn't. They do them in the United States. And really what the L's ask of you is to take pictures. They want to see pictures of the facility with signage with employees, right? And so you have that. You have the lease or the deed. You might have not a blueprint, but a diagram of the space and all of that sort of stuff. And yeah, I mean, it's a pretty intensive list of things you have to have on both the foreign company and the American company, and you need to have both of them. So I have conversations almost daily about people saying, well, let me get the L visa first and then I'll hire people. The regulations permit you to do a startup L, and maybe you can have a couple of employees and you'll say you'll hire more. But if you do it that way, they often will give you only a year. And a lot of times these people that don't want to fully invest, when we're suggesting that they do at the beginning, don't in that year anyway. And then they're in a lot more stress trying to get to those 5 employees. So we pretty much convince our clients, if we're going to represent them, jump in, don't stick a toe in, jump in, invest enough money to hire 5 employees, rent a space, really do it that way.
Most of our clients are doing the E2 as the non-immigrant option, but we have had clients do the L1, and generally they're investing at least 150, 200K. Yeah. And it's a business that they need to have those employees. So they need to have 8 employees. Like it's pretty much
Mhm.
mandated by the franchisor
Yeah.
to be successful in the first year.
Yeah.
You need to have, and there's some businesses that are well suited, like caregiving, where you have, you're an executive, you have a staffing manager, and then should have 20 caregivers in the first
Yeah.
year. So that's a lot of employees, and they're all W-2.
That's a great model, right? And so, many times when we have people that don't want to jump in all the way on the L, we do the E, just as that example of the case I did, and I was talking to them today. So, we look at that. Now, the E, of course, is only available for 33 countries, and the L's open to any country, right? And so that's why they look at that. And so, but the L leads directly to the EB-13, and the E doesn't, right? So the E doesn't get to be an EB-13 if there isn't a foreign company, and if that person didn't work in that foreign company for one of the last 3 years in a managerial or executive role, and also has a managerial executive role in the U.S. company. So what we did in that one instance we talked about today is we told them about that, so that we will move to that. And the E visa and the L visa both toll that one in the last 3 years requirement if they're in the United States working for that company on another visa. So there's one option, right? Go to the EB-13. The L has the issue that it's only good for 7 years for L1As, that's the executive and managers, and 5 years from the L1Bs. So the E can continue to be, extended. So it's cool for that. But the L is that other option. Now, here's an interesting visa that came out. Maybe you don't know about it because it's not actually a visa; it's a parole. The difference of a parole and a visa is that a visa is established by requirements, i.e., there's some sort of congressional element in it, whereas a parole can be invented by a president. Okay, so this one's called the International Entrepreneur Parole, IEP, and the IEP was created by Obama in his last 8 days. He did a lot of stuff in his last 8 days. A lot of great stuff stuck. Trump killed it, and Biden resurrected it, but to very little fanfare. It's adjudicated by the same group that does the EB-5s, and they're going to look at it with a hard eye. So the IEP is, instead of the E2 where you're investing your own money, this is where you have somebody else's money investing in you. Okay.
So it could be like a venture capital fund.
It could be. But most venture capital funds usually look for higher amounts of investment than these early stage startups, right? So really, I think that's the funny thing. They were going to do an EB-6. There was a lot of communication about it. The VCs were behind it. And they did this IEP as well. If you read the historical background on it, it's really designed because the EB-2 national interest waiver has been underutilized. And this is to be a non-immigrant version of that, right? And so it can lead to the EB-2. It can also lead to the EB-1, which is, I'll tell you why we're focusing on that. So the IEP initially required an investment of $250,000. They have made a formulaic uptick of the amount. So it's now like $267,000. So you have to raise $267,000. That money must be raised from an experienced U.S. investor. Okay, so instead of a VC, I really think it's more of an angel,
Okay.
because of how much money it is. Now, It can be 20 million, but the threshold, the bottom is 267. If you're raising 267,000, you're probably
usually
doing
that's pre-seed, not
pre-seed.
yeah.
But it can't really be friends and family because it has to be an experienced investor. What does that mean? Okay, so that means this investor has to have invested in 2 other startups in the last 5 years for a cumulative amount of $630,000, right? It was 600. They notched it up a little bit, so it's a little over 630,000 in the last 5 years. Now, here's what makes this difficult: they have to prove it, right? So you've got the investor, or you got the applicant who's glad to tell you anything about them. Now their investor doesn't just have to tell them, has to show them their passport to show they're an American, but they now have to show some other company's information. So here's my term sheet and my,
opening up all the old deals.
Debt safe that I signed with this other company. And we have to show that company had some degree of success, which is either 5 jobs or over $155,000 in revenues. So now you're going to have to get them to, show their taxes and things like that. So because of that, it's hard to get that information. Now, we've been successful to do a number of those, but it's been pulling teeth, especially when we have been dealing with VCs. Are like, what are you asking me? Are you really asking me for somebody else's information? I'm like, yeah.
And you're asking for someone that their time is super valuable.
Oh my God. Yeah. VCs are tough to talk to anyway, much less talking to them about somebody they've already invested in and somebody else they've already invested in and giving that information. But anyway, that's what you need. And so you can do that. So you get, you have those thresholds. There's a minimum amount of investment. And they have to have a minimum of 10% equity in the company, right? But 3 people can do it under that same investment. So you could have your CEO, CTO, COO, I'll get that deal. Now, what's really cool about that, and I really think for the country of India, is because it can lead to the green card so much faster than the H-1B.
And why is that?
Yeah, it's really cool. I'll take you through it. So the H-1B typically leads to the PERM visas, EB2s and EB3s. Okay. India and China and other very highly populated countries have very, very long waiting lists for those green cards, right? Now, it's hard to go from an H-1B visa to an EB-1 because you're usually buried at a bottom line. Like, you can't be, while technically you can own your company and have an H-1B, it's hard to be the CEO on an H-1B because there's a thing called prevailing wage, right? So you have to pay the prevailing wage. You got a Silicon Valley, Bay Area startup, and you're the CEO. Are you really going to pay yourself $250,000 a year when you really don't want to pay yourself anything? And you're pouring it all back into your company, right? It's a business model that doesn't work.
It doesn't make tax sense.
Yeah, and if you say I'm just the developer, right? You can't have a LinkedIn that says I'm the CEO, right? Because then they're going to say you undercut the prevailing wage. So these guys are stuck, having to work as developers, and they can't hold themselves out as CEOs. And the EB-1 green card is all about holding yourself out, right? So the EB-1 extraordinary ability green card is what we'd suggest guys and women on their IEPs go for. Okay, so the EB-1 green card, it used to be current for Indians up until just about a few months ago. Then it went to 10 months. Okay, but that's 10 months as opposed to 12 or 15 years, right? Meaning that you can really get a green card within a year, and you can probably get from an IEP to that green card well within the 5 years that you'd be able to get the IEP. All right. So what we'll, again, just as we gave this strategy to the E2 holder that here's how you get the green card, when we're talking to IEPs, we're telling them start working on this stuff, right? So the EB-1 green card is really, to how I like to describe it, is what is your industry and what's your niche, right? So in your niche, you may say, okay, I'm an AI developer, but we developed the coolest AI that goes to the making of, I don't know, some Japanese anime characters that are gonna, be in this game or whatever, right? So that's your niche. That's what you do. But the EB-5 is all about what kind of notoriety did you get for it, right? Did you win any national or international awards for creating this either tool or product or character? Were you the subject to any major media? Did you get invited into any elite organizations that have a threshold of success, outstanding achievements to get into it? Did you write any scholarly articles about it? Did you get paid a really high salary? Did you hold a key role for an organization with a distinguished reputation, right? Those are the types of things. Oh, were you the judge of the work of others? So in a technology space, there's a couple of these that are pretty easy to pick up. Judge of the work of others, go get in hackathons, right? Go judge other people's products. Membership in elite organizations, find the elite organizations. It can't be a pay to play. It's not like the big organization that lets everybody in, but it's the one that has this threshold, but find out what it is and get invited. Now, if what you do in inventing this really cool anime company is promote yourself, right? Get a publicist to push it and you out there to show, as the CEO of this is all the great things we did, right? And so then you got publicity. Then
helps your business, helps your immigration case.
You become a thought leader in your space to get the green card, but then you're a thought leader in your space, so you got the business, right? It's a win-win across the board. So while these guys are launching their company under the IEP, we're giving them focus on what you're promoting. right?
And that would be IEP to EB1A essentially.
Yes, absolutely. Okay. So that's how they can get the green card in less than a year and not wait in line. And now they're
because out of all these years, I've never had a client do E2 to EB1A. I've had them go other ways, but it does seem like a big jump, kind of like you were saying with the H1B.
You can
There's
totally
generally other categories like the EB2 and AW.
Well, it depends on what you're doing, right? So in the franchise space, if they're buying a McDonald's franchise, it's going to be hard to be an EB1 from a McDonald's franchise, because how do you differentiate one McDonald's from another McDonald's? It's a franchise. It's the same thing, right? So you'd have to do other things within that to do it. And you'd find some special cause, some special approach that you're going to get notoriety and win awards for, right? So you're giving back in some other way. So whatever the company is it prone to promoting yourself to being great and rare in it, right? That's really what it is. How are you the best? Now, you get to define the lily pad, right? Or the pond size, right? You can be the very best, very tiny pond frog. And so that's where we get to define what we're going to do and how one's great at it. They don't get to. Once we define the game we're playing, they then poke holes in it. But that's a way to think about it. And if someone's trying to determine, right, I want to go to the EB1 after I have the E2, okay, what kind of job can you really show you're great in, right? And that's when you would select the kind of company or the kind of business you want to start. Is it one that has blue water, as they say, or are you just going to be one of millions doing the same thing? So that's one way to look at it. Which then it goes to the EB2 national interest waiver. So the reason the national interest waiver is not great for Indians is it's still an EB2, right? Still going to be waiting 12 years to get the green card. So go EB1. EB1s and EB2 national interest waivers aren't really that different. They're one's outstanding, one's extraordinary. You're becoming great in both of them. But if you have a plan on how to hit those achievements, might as well aim at the EB1 criteria. They're not significantly different or harder.
And the processing time, I understand they both have premium processing. Like, is it 45 days, 60 days?
15 days. But they very seldomly do it in 15 days. They'll issue an RFE
by the time.
And then you have to respond it. And if you put everything in, then you've got to find new stuff, right? So it's an interesting dilemma on a national interest, on a big, sophisticated, highly discretionary green card using premium processing. You can use strategies where we're going to hold something back. We've got two elements, we're going to have a third, whatever it might be, so that we can say something. Or what we do is we call it drilling down, right? So if they say we don't think it's sufficient evidence on this, we'll go back to the expert. Experts are really critical in these, by the way. So we go back to the expert and have the expert say, I understand a question's been raised over issue A. Please allow me to further clarify. And then they can bring in source material. So it's really important. I break down evidence in three ways. The primary evidence is like a brick. It's an award, right? Secondary evidence is an opinion letter, whether it's an expert who is somebody doesn't have a vested interest, but understands and has a perspective in the whatever industry or sub-industry or specialization to talk about it, or it's a testimonial letter. That's a witness, right? So experts aren't witnesses, and experts don't have to be and shouldn't be witnesses, right? So think of an expert. What we're doing is we're litigating on a piece of paper, right? If we walked into court and there was a murder, then the expert would not have seen the murder. They would have looked at the gun or the knife.
They shouldn't have a vested interest in this.
They wouldn't have a vested interest. They wouldn't be part of it. They would look at the gun and the knife and the hair follicles and the DNA, and they'd say, based on my expert opinion, when I look at these things and I look at the source material that I'm reviewing, I can tell you it's a 99.99% chance that the defendant was the murderer, right? That's what we're doing with an expert in EB1s, right? So I'm an expert in this field. I have reviewed the evidence. Here's the significance of this award, right? And then they talk about, here's how many people go in the award. I've looked and I've done some research on the award itself. Here's what it says about it. Here's what other people say about it. And what other people say about it is what I call tertiary evidence, right? Doesn't reference to the beneficiary at all. It just references something like in the award. But it's that tertiary evidence that gives the expert opinion girth, right? USCIS hates plain letters. They hate, well, this person's great, I say so because I'm an important person. It doesn't work. They need to have the evidence, and they need to have the evidence explained to them. And that's where the brick has the mortar around.
You've got to make it easy for the adjudicator with all that credibility.
Walk them right through it. Well, in experts, it's not any. Immigration doesn't have experts. They don't have a body of experts on everything in the world. They don't have any at all. They have an adjudicator. Maybe they don't even have a college degree. Whereas an expert breaks the tie, not just because the expert's saying that, but there's a case called Beastech, which is the Supreme Court's case that says that experts' opinions are evidence, right? So you've now taken what was a discretionary thing, whether or not it is A or isn't A, and now you have an expert tell you that it is A, right? So they have to defer to that. They don't always, and I just had a case denied, but I won it in court in San Francisco last week, where they didn't analyze my expert opinion. And that was the basis of the case. That was an arbitrary and capricious decision that you didn't even analyze what the expert said. You just dismissed it. And so we sued them. They asked for a stay to try to give us a new denial. They didn't hit their date. And I said, I'm not extending it. And so they just approved it. But, that was all because we built
our the litigation path. I know that's like plan C, but like how much time can it be? Like 6 months to 3 years? Is it like a really wide range?
This one, look, they dismissed it before they answered it, but they asked for a 90-day stay, and then they get 60 days to answer. And then they kind of jacked around with us on whether or not we actually served them sufficiently. It was a little cheeky on their side, but probably start to finish, it was 180 days, probably 6 months to do that, to get the litigation approved. And they don't always do that, but the reason we won it is because we used experts. We had them sufficiently discuss why something met what it was, and we briefed it. And I told them about the Beastech case in the brief. I told them up front, basically, if you don't agree with this expert, we're going to sue you. I didn't say it like that, but I put it in there. So then when we did sue, we put it in there and indicated that here's the expert, here's where we cited that this opinion, here's the case. And that, I think, was what put them in a position that they couldn't fight it.
For your EB2NIW clients, you've had many more than we have. Are they mostly doing an entrepreneurial venture, or are they mostly working at a company like a pharmaceutical company? What do you usually see?
They can be working there. They just need to be in enough position to really be driving the enterprise, right? So you have to have a letter about, what are they doing, right? They have to be in a position to impact what they're doing, right? So they should be in a discretionary role. They should not be in a receiving the discretionary role, which can be a little complicated when they're not the CEO, right?
Yeah.
But are they the head of technology? Are they leading something that is really critical to the deal? And the farther they are down the line, the more you're going to have to discuss that with a testimonial letter. This time, this is where the company will go in and say they've done this, this, and this, and here's what they did, right? In his position, he invented this thing that we've now patented, which is now in commerce and 1 million people uses, right? That's a winning argument.
What we're seeing is a lot of remote workers all over the place, and they've been working remote, whether it's a software engineer in Argentina, and now the California and New York companies have switched to a hybrid approach, and they want these people here. They want them working in the U.S., and they're happy to take a pay raise from 120 to 200K plus living in the U.S.
Sure.
For those cases, it would be basically like expert witness that's outside the company, and then you have a testimony from like the CEO or some high rank.
100%, right? So those letters serve different purposes, right? So remember we talked about the brick and the mortar? Okay, so the brick in the employment position is the employment agreement, right? And it's the payroll records and the taxes to show that he signed a contract that says he's going to do A, B, and C, but it's forward looking because he signs it on his first day of work. Doesn't say what he's accomplished, right? It says what his duties are. and without any real gusto. It's like, you're going to do this, this, and this. Then these other things are show that he actually got paid. But that by itself isn't sufficient. So that's why you need the letter from the employer to then describe. He says, look, Exhibit A is the contract that we executed with him. Here's what he does. Exhibit B and C are then examples of that, right? So it would be work product, right? Like, he invented this. Here's a copy of the patent that we had patented for him. Here is some screenshots of, the technology invented. Here are our revenues for how much money we made off. You see the breakdown of the product that he had, and that increased our revenue from year 1 to year 2 by 100%, right? Something like that. That's the kind of way that you would use a testimonial letter of the employer. The expert would say, okay, I'm an expert in this space. And I can tell you that the leading product in this space does 1, 2, and 3. I've reviewed this technology. Here's what it's doing. Here's how advanced it is. And this is why I think it's important. Now, let me also tell you, I can see how many people are using it. I have reviewed the employer letter, right? And I've seen those reports. I'm also going to show you an article I found that says this other thing about it. Now, I'm going to take all those things, and my expert conclusion is ABC. So you see the different roles they have that are both important. And by having the expert, one, you have your expert evaluate it, and you get the BSTEC case to support it. But two, the expert can't say what they did in that work directly. You need a witness to be able to say that. And that witness should be a superior person in the company. And it should be an executive level person in that company, which is sometimes hard to get. I mean, if you can't, you can't, but that's the ideal author of that.
How do you see, like, for the EB2NIW or even the EB1, like, done versus what you are going to do?
I think that's the difference of the EB2 and the green card. I think it can be more forward-looking from the EB2 national interest waiver, and it has to have accomplished in the EB1 green card if you want to make an extension, right? So whereas a green card's not going to give you an original contribution for a mere patent, it has to have been in commerce and has to be significant. You might be able to get an EB2 that you've invented something that will, solve hunger or something, right? This product is going to take all the salt in the ocean and make,
but you haven't got any awards yet. There's nothing yet.
Yeah, you haven't done the awards yet, but you've really done something really cool, and it's going to generate the company, and so it can be a little more forward thinking. I think it's hard to get one at the very beginning, right? But you can be in the middle of your first win, and I really think you have to be through win 1 and maybe even win 2 for the EB1, right? I think you can get the O1 early on, but the EB1 has to be more sustained. They have the word sustained, where the national interest waiver doesn't have that. And you can rely a little bit more on the education if they have an advanced degree, and some other things. So it's sort of designed differently. We go EB1 when we can. We'd almost use the EB2 as a drawback. One, again, what's the priority date issue if we're dealing for people from India? And two, EB1's definitions are a little bit more known, right? I think we're more comfortable where the out of bounds lines on that. I think EB2s are fuzzier, but because they're fuzzier, you might get some wins where you wouldn't have gotten the win in the EB1. You just know that you're not going to get there. I can take a gamble with the EB2 national interest waiver and maybe get one, right? So it's lawyers are going to look at both of those things to try to see what's the easier fit.
Jon, thanks a lot for summarizing those. So we've gone through EB1C, EB1A, EB2NIW. Say you don't qualify for those 3. Yeah. I know at Visa franchise, we've had clients where it's often the spouse will do the PERM process, as you mentioned earlier, on the EB2 or EB3. Would you mind just going through a little bit about those options for whether it's the principal, the investor that's on an E2 or other non-immigrant status, or maybe the spouse that has work authorization?
100% glad to. Before I jump there, I want to add one more thing on the national interest waiver. The national interest waivers, one of the national interests can be creating jobs, right? So think of it like this. You're asking immigration to make a trade. Instead of getting the PERM process, which we'll go in a second, and you'll hear more why, where I need to prove that there's no American willing or able to do this job. Instead of going through that process, I'm going to ask you to waive it. Here's why. I'm going to create 10 jobs for Americans, right? So instead of me proving that my one job is there, I'm going to make that, by tenfold that we're going to do that. So
this could be like you're opening up a STEM franchise where you're going to have 3 locations over a couple year period, and you're going to have 15, 20 teachers, and you're hiring Americans.
Well, and what I would do, a lot of these guys are on E2s already, right? You're trying to find the E2 into something else. When you're E2, you can probably get an E2 with 2 or 3 employees, right? Yeah. That way you haven't merely created a job for yourself and your family. That's kind of what the regulation reads on. So you've got a couple other people, but maybe you advanced it where you had 10, 15 employees, right? Now your thing, whatever you've done, the national interest is in the employment creation, right? I think that's a really cool way to go from EB2 to EB3.
I like that. And we get asked all the time, well, what about the EB5? Can I turn to EB5? I'm like, you can, but the wait is like, 8 years to get the final green card. And
good point.
You're going to have to take cash out of the business, pay taxes, reinvest the cash. So it's possible, but
PERM, and then I'll do EB5 because I've got kind of opinions on both of them, but that's great. That's a great thing. So I'll come back to that, I promise. So on the EB2 and EB3, that's called PERM. That requires a labor certification, as we just talked about, proving that there's no Americans willing or able to do the job, right? Well, how do you do that? Well, it's a game, right? It's a game by sampling the job market. And I think most people that are involved in that sample kind of know what it is, but you don't really, right? So you got to run these real ads, and you may have no intention to hire anybody. And you really don't want anybody to come forward if you've already got the foreign national in mind. And many times you do, right? I want to go from my EB2 my E2 to a PERM green card. Now, the first thing on the E2 is you can have an ownership interest in a company that files an EB2 or EB3, but it puts a lot of pressure, right? Because you're not even supposed to be involved in the process, much less be the decision maker in whether or not you're going to hire that person. So the regulations say it's permitted, but it's tough, and it might kick it to an audit. So I don't know that I would do that. But you talked about spouses, right? So if husband is the E2 visa holder or wife's the E2 visa holder, then the spouse first, they get this employment authorization document. So that usually means they're out working anyway. So they have a job, that company can then sponsor the spouse, and the spouse doesn't have the ownership interest. Now, the important thing is what industry is the spouse in, right? Some industries have such a low unemployment rate, like some of the technical fields, the only people that are going to come forward are going to be foreign nationals, and that's okay. You don't lose that. So they have to be Americans or green card holders, and they have to be willing or able. So the key of the PERM cases is how you define the job. And you define it in a way that is restrictive instead of open. And so it doesn't really read like a real job description. So it'll say there's a thing called a SVP, Specialized Vocational Preparation, and then that has a number, and that number tells you really what is the typical amount of education and work involved. So it may say a bachelor's +2 or something like that. Okay, so if you're going to go beyond bachelor's +2, you have to have what's called a business necessity for that. And then you'd say, okay, we need bachelor's +5 in AI development because we're doing AI development for $1 million banks. And we, 2 years just isn't enough, right? You can do it, but it's another set of analysis. So you look at that SVP and you create a job. So if say you're going to say it's 2 years experience and you're in a tech space. So then you can define what that knowledge is. You don't just say have experience in developing AI applications. You would say has experience, 2 years experience, AI applications in finance using, JavaScript or, some sort of technology that they've used. Then you would have to prove that with letters that said that they have worked for more than 2 years, and not in the same company, by the way, right? You can't train somebody. I can't go from OPT to H1 to green card and use that experience because they could have trained an American. They have to have found it somewhere else, right? Now, many times they've done that overseas or whatever, but some straight from college right into work, and they've only worked at the same place. That's a little tricky. There's a case called Deletizer that says you can work in the same company if the job is 50% different than the job they had. So then you have this little Deletizer chart, and it says, these are all the criteria in the job A. These are the job criteria of job B. Look, they're more than 50% different, right? That's a way you can do that. So if they go up the food chain, we're going to hire a manager, and the manager needs to have done this, these things to understand the knowledge of the job. But these other things that are more than 50% are leadership things that they didn't get experience from here. Okay, so that's the EB2 and EB3. So what's the difference of an EB2 and EB3? An EB3 can be a complete no experience necessary job, or one that has a bachelor's degree. One's skilled, one's unskilled. The EB2 are for master's degree holders or higher, right? Or advanced degree. So that's a master's or PhD, or 5 years experience. Okay. So, but
5 years experience in the field that they're going to be working in.
Yep. So if they have 5 years experience in the field or an advanced degree, then they're EB2. And if they just have a bachelor's degree, they're EB3 skilled. If it doesn't require a bachelor's degree, it's what they call unskilled. And you literally can have one where there's no experience necessary. Now, the gamble is when you file this, you have to advertise it in 5 ways. One's for 30 days with a state workforce agency. Another is in the largest newspaper in the metropolitan statistical area on the Sunday 2 times. You got to post it at the location of the company. But then there's 3 there's options of about 8 to then pick 3, which could be on the company's website and a number of other
radio
ads. One, there's a number of ways to do that, job fairs. And so that's typically about 30 days of advertising, because the state workforce is 30. You can try to put the rest in there. That's a good idea. And then there's an additional 30 days of what they call a quiet period. And then if any Americans come forward, you need to interview them. And then determine whether or not they meet that. And that's where the requirements of the visa are so critical, right? Because they can say, well, I have 1 year experience in this. Well, it requires 2. So that's how you would eliminate them. And those are the PERM cases.
So imagine they make it, no one applies. I guess the Labor Department would then issue the PERM. What would be the next step from there?
Yeah, so I didn't really take you through the steps. So the steps are this. So the first thing you do is you file what's called a prevailing wage request. That used to be an automatic. It used to do it instantaneously. Then they created a prevailing wage determination center, and now it's taken more than 6 months. So you wait for 6 months, then you get it back, then you run your ads. You run them during that period of time. You pay for all these advertising fees. The employer has to pay for all of this. The employee can't pay for any part of that. Then when that comes back, if there are no Americans willing or able, you would keep a little audit file that you have to keep for a while. And then you would then submit your labor certification process to the Department of Labor. It takes them about 6 months to approve it. Now you have the labor cert. The day you file the labor cert gives you a priority date. That's when priority dates start, which is important. When I was telling you later, some countries have later priority dates to be able to go. Okay, so once you get it back, then you file an I-140. You can premium process the I-140, and if they are current, and they are current for EB2s and 3s in most countries of the world right now, except for the really 5 big ones, you can adjust your status and file that at the same time, called concurrently. So if you're on an H-1B or another visa, you're adjusting your status. The premium processing can give you the I-140 within 2 weeks minimum, but there is no premium processing for the adjustment for some bizarre reason. I don't know why, because the adjustment of status should be the faster decision, right? It is, have you been arrested or convicted of a crime? Do you have a disease? Are you a terrorist, right? And I guess
what are you seeing that taking right now? I know it's how much time are you seeing that take? The adjustment?
At least 6 months, 6 months or more. And then during that period, they give you a work authorization, a travel document. something that should come stapled to your receipt, right? Because there's literally no discretion. But then that's going 8 to 13 months right now. And I don't know why, because all they got to do is create a driver license size document and mail it to you. Who cares, right? Give me a receipt that says I can work and travel with my receipt, or put it on my receipt notice. This allows you to work and travel. That's what they should do. Because they don't do it quickly, you're stuck in the country, except for a few visa options: E2s, L1s, H1Bs. Yep.
And I've seen that with friends here in Miami. Even my spouse, my wife couldn't work for 6 months, just waiting. And we couldn't do much.
I think I was wrong on E's. L's and H's are the only ones that can go in and out, right? So O's can't, and things like that. So they're stuck here, and many O's are entertainers or athletes, and they're international athletes. It's such a real pain. That would be an easy fix for immigration to do, that I don't know why they don't. Because the funny thing is, they'll eventually issue this work and travel, and then if the visa is denied, they revoke it. So why not just give it to them immediately and revoke it if it's not? I don't understand the wait. It's such a pain for people, and
antiquated process. And how do you see it? Like, how do you see what's like the proper way that an employee, maybe they're already started working for 3 months, 4 months, or they're in the negotiation, like how can they get their employer comfortable with the process from like a time and financial aspect? You mentioned the employee can't pay for the PERM, but can they pay for the immigration lawyer? What can they do to make it as easy for the employer to get to sponsor their green card?
We break it into 3 phases. Phase 1 is the labor certification process, which also includes the legal fees. They can't pay for that either. They could pay for the I-140. They can definitely pay for the adjustment of status and the filing fees that are associated with that. And those fees are not unsubstantial. They're big. So you got about $1,225 in adjustment of status fees for each adult, and then $750 for kids under 14. So that can add up with a family of any size.
Interesting. Yeah. So, I imagine some employers will pay for that happily, but if the employer's on the fence, just offer, I guess, imagine to pay as much as you can.
That's right.
So you can smooth the process.
Yeah. You just can't the first part. And honestly, the first part belongs to the employer, right? I'm looking for a position.
Hiring decision.
Yeah, it's a hiring decision. And then once they have that labor cert, then the individual is really brought in at that point. So that's EB2 and EB3. Talking about spouses could file it instead of the E2 holder. E2 holders do have to file an 802. It's an additional form saying, I don't know, you understand the treaty elements of it. So the EB5, which we talked about, has undergone some changes in March of last year, kind of opened it back up, right? So it was a few years ago that they, under the Trump administration, they raised it from $500,000 of the minimum investment into the TEA, or target employment area, which is rural or high unemployment zone, to $900,000. And then they raised the 1 million regular to 1.8. The Trump administration had a habit of not following the rules when it changed that. So they are always exposed to litigation, and the litigation never turned, well, I would say never, many times the litigation didn't turn on whether or not there was any basis for doing it, but they just didn't follow the regulatory rules in doing it, right? They just ramrod it through. They didn't put it out for comment and that sort of stuff. So the court knocked it down back to the $500 million number. And then 2 weeks later, the EB5 regional center law sunsetted, because these laws actually have expiration dates. And because all this stuff was going on, they just let it sunset. So it stayed, without the ability to do regional centers for a little while. Now we had a
few EB5 direct clients. We haven't done many, but during that period, we had a few.
Yeah, so there was about a 2-week period where they dropped the regional center back to $500,000, and we did 2 visas in 2 weeks for these guys under the smaller amount, which are still pending. So they reinitiated the regional center recently, and they pulled something that was really weird that was available under the standalone. So you could have, which I thought was awesome for franchises, especially hotels, convenience stores, and restaurants that you could put on highways, because they could be rural, right? But they could have incredible traffic counts. And you could say, I'm going to build this big center and I'm going to drop in 10 investors. What they did with the other thing is they now say, if you have any more than one investor, so if you have two investors, they can't be in the same project, right? One investor can invest as much as they want, but you can't have two come in at the amounts, which is now 800,000 and 1,050,000, right? So you can't have two $800,000 investors, even if they're brother and sister or family members. It's just insane. So, but the reason is they want them to be in the regional center. So it's to be a designated regional center now to do the multiple investors, because there's some protections in that. Regional centers have to stay compliant, yada, yada.
Registering agents, there's an integrity fund.
Yeah, there's all that stuff, right? So that's the change on that end. So I think the regional centers are going to go back to being the cash cow that they were. But immediately regional centers went and got filled up and started getting, longer priority dates again. But there's apparently now 5% will go rural. Another 5%, I think, go to high unemployment. So I think what were the lower ones are now having some quicker adjudications. Tough to tell.
And then, nothing that the government's published, but talking to colleagues that work in regional centers.
That's right. And so there's, I think, an industry for renting regional centers, as they say, and that's like taking a project, dropping it in a regional center, and then and going from there. Regional centers can make money that way. But then, picking the right regional center is important. You want to do your due diligence on them. You can't refer someone to a regional center unless you have a brokerage license. That's important to find those people. So EB5s can be a little complicated, but I like to look at them from the perspective of the investor. I'm not attached to a regional center. Some people, all the there are EB5 people are only attached to regional centers, so they're only going to talk about theirs, right? So I think it's important for people looking at that to have an attorney be able to help them understand what that is. But then they need to have a broker that would then pick the regional center with them. The attorney can't do that.
For sure. Yeah, now there's a lot of FINRA licensed brokers where there should have been in the past, but now it's mandated.
It's funny. I think an experienced EB5 immigration attorney could probably do that due diligence as well as a broker could, but they just haven't allowed that to work that way. But I mean, one of the things that we would look at from an immigration law perspective is this going to get approved, right? Yeah. The brokers are going to look at, is it a good investment? Well, it's not a good investment if the EB5 doesn't get approved.
And what the objective is. If it's kind of like preservation of capital, green card, return on investment, and what's the priority? Usually green card's number one.
I think green card has to be number one, because if the green card doesn't work, then the whole reason to do it wasn't. Now, I like people that use the green card as gravy. And I tell people, invest in the best deal, but the EB5 structures are often very, very little return on investment, right?
I saw an ad on Google, high ROI EB5 project, and it was 3.5%.
Right.
And it's high. That's what's inflation now? 6-7%?
Yeah. Well, it's that. But here's the gig. The only reason you'd have an EB5 would be that it's cheaper than a bank, right? I mean, why would you go through all the problem of getting, bank rates or higher for this, unless it was
a lot of individual investors, like some of these regional centers, or those renting regional centers, are pretty sophisticated, and they could easily get 10 million, 20 million from a family office. And it's a lot of work having a bunch of small investors at the 800K or $1,050,000.
100%. Right. Yeah. I mean, that's the gig. So that's why a high return on investment is only 3%, right? Yeah. It isn't going to be
all relative.
Bank, or you wouldn't do it.
Well, John, I know we're at the top of the hour. I want to be mindful of your time. Do we need to stop the live stream, or is it okay to field some questions?
Give me 1 second on that.
Sure.
Let me see what's sitting there. The guy did give me a note, but that's okay. No, I've got some time.
Maybe 10 minutes. Is that okay?
That'd be fantastic, of course.
Perfect, John. So we have Samantha Johnson. Hey, what's the average processing time to change from E2 visa to green card?
It's going to be based on the green card, Samantha. Yeah. So there is a thing, you can actually type in processing times into USCIS has a calculator. I find it's a little longer than reality because I think it's real time stuff, and I think some of these guys get stuck sometimes, so those are going to skew and make the average longer. But you can do that, and it depends on which service center you file with, right? So the so the I-140s and the adjustment of status are going to go to different places. But I think most green cards, well, if there's not a priority date issue, I think you're looking at about a year and a half or more for an EB2 or 3, and you're looking at less than a year for any of the EB1s. None. The EB5s are taking about a little more than 3 years to get the I-526s approved. Then you got to, wait a year and a half and then file the I-829, and that's going to take at least that again. So, I hope that answered your question. There's a couple of different types of visas and a couple of time frames, but those are some averages of the main ones.
Thanks, Jon. And then Aziz is asking, are there special qualifications to make the change to green card?
Well, we went through all the different buckets, Aziz. There are different green cards that have different criteria, and they're substantially different from each other. Yes, there are special qualifications to change to green cards.
And then we have Maurice. Can the E2 visa investor purchase commercial real estate like investment properties, multifamily apartments, etc.?
Sure. Yeah, we've done that a number of times. Investment companies can do that for sure.
What would you say you want to see 2-3 American jobs?
Yeah. I mean, have a company that somebody's answering the phone, opening the mail, do those things. You can also create some job creation companies around it. Maintenance companies that take care of your commercial property, for example, can do your commercial property and then go out and do other people's commercial property, right? So those sort of things. But, the E2 only needs a couple of employees, as opposed to the L1 that would need, at least 5. So I think a small company, that could manage the operation would be perfect.
And how is it? Because I know we've had the question in the past, and it's somewhat related, like using debt. So say you're buying a multifamily property for $5 million, can you lever up and just do like $1 million cash and then get a loan from a bank for $4 million?
Sure. For the E2? Absolutely.
For the E2.
Yeah. I mean, you've invested. Matter of fact, you can borrow the entirety for an E2, right? As long as this is a big but, or a big not but, a big condition. As long as it doesn't attach to the property or the company, right? So you can borrow the money against your house, your car, your assets, or have it not secured. But if it is secured, it can't secure the company, or they're going to say that's the real investor, right? So that's a mistake you can make and not know you make it until they look at the loan document, and then you got an RFE you can't answer.
Thanks for that. So it really matters how you collateralize the debt if you want to go that path.
Yeah, the debt's completely fine.
And then you have Julio Martinez. How can I apply for the E2 visa? Any tips from starting from zero?
Yeah. Well, look, the amount of investment is the first thing. Do you have 100,000? That's what I'd say it's a good place to start. Do you have a company you want to invest in the United States? You can start your own company. You're going to have to own at least 50% of that, so you can have a partner, and that partner can also get the visa too if they also put in the same amount. So that's a good place to start. I'm sure you can call Visa Franchise or call us. We're glad to give you a strategy session on your particular facts.
And Jon, what's the best way for people to schedule that initial immigration strategy session?
So OnlineVisas is not just the name of our company, it's the name of our website, onlinevisas.com. You can go there, you can schedule a strategy session. You can email me or my assistant. I'm jon@velielaw.com. So JON@VELIELAW.com. Thank you for that. And we're glad to have a free strategy session, and we'll show you our platform, visas.ai, where we'll take you through the strategy session, and then you'll have access to your own portal you can go in and see the questions we asked and the answers. And then if we think that you are a good candidate, we try to answer 3 questions. Do you meet the qualifications for the visa or have options? how long does it take and how much does it cost? And then if we think we can get you the visa, we'll send you a contract that day, and you can immediately move forward, and we're glad to help you.
Jon, I really appreciate it. And your level of transparency, I haven't seen with any other immigration attorney. And I think that really gives confidence. And it's like, this is what we're doing. This is the information you provided. This is what we can do, sharing your screen, and it's all there. And the level of communication is greatly facilitated with like the technology stack that you've developed. So congrats on that.
Thanks, Patrick. It's almost necessity being the mother of invention, right? So I decided to build an immigration firm in a town with a very small population of 100,000 in a state of only 3 million without a lot of immigrants in it. So I had to learn early how to get business over the internet, right? And so when we launched OnlineVisas in 1998, we kind of changed the way lawyers were even presenting themselves over the internet. And it seems kind of silly and basic now, but we did something we called a menu of visas, where it would have the name of the visa and maybe a sentence. If you clicked on it, it would give you a bunch of information, and then you could communicate with us. And so we started signing up some fantastic clients like Tyson Foods and Bell Laboratories and around the country. And Bell Laboratories is like, we're in New Jersey. We don't want to drive all the way into New York to see our office. We love the fact that we can talk to you. You take that and you speed it up, and COVID comes and Zoom's there. I do this all day, all the time. And I really think what you just said is, I think, how you build trust. And so one, video, we trust people more if we can see them and see their mannerisms, and maybe see that they have some degrees on the wall already. That's what you do in a person-to-person conversation. Now we can bring it to anybody's, living room or office or home or whatever. And then I think trust is built on a couple of things. Number one is knowledge, but not just knowledge. It's empathy and engagement, right? Like, does this person know what they're talking about, and do they care enough to do my case, right? Are they into it? Are they committed to it, right? So those are kind of the two big prongs of trust. And if we have an opportunity to do this, whether it's on your show or in a face-to-face free strategy session, that's us investing in a client first. And then we found that works, and sort of better than the alternative, and kind of better than what was there before. And I wouldn't want to, take the day off work to go talk to somebody when I can do it within 30 minutes to an hour and do it right from my desk, right? And so that's where we've gone. So this is
you can work with the best attorney, not necessarily the one that's close to you.
100%, right? I mean, we're not limited by geography anymore for anything, right? So why should lawyers have to be down the street, especially in immigration law? Because if you're licensed in any state, you can practice in all states. And I have clients in literally all 50 states, and over a history of the now 30 years I've done this, pretty much every industrialized country. It's been pretty interesting, and that's what the internet has done. I think a lot of immigration attorneys they come from a community, right? Like a Mexican kid goes to law school and represents the Mexican community in his town, or they're Chinese, or they come over as an immigrant and they want to give back. I mean, look, I love that and I get that. But being an internet attorney, I get all sorts of different nationalities and all sorts of different industries, and that makes for a fun, life and career.
And then volume, where the knowledge compounds, where if you're just handling one community and you might just do 1 or 2 E2 visas every year, you're not doing the volume that you can really give the right strategy and then execute the case appropriately based on what's being adjudicated.
100%. Yeah. No, that volume is really the key to immigration. You got to have enough people, and that's really where, we figured that out a while ago, but it's easier said than done to get it. You have to have great shows like yours, great websites, great social media presence. People are always looking to find people. So that's why we love to be on your show.
Thanks, Jon. I really appreciate all the time you spent with us today. And we put maybe Sabri, you can add again for those that want to schedule a strategy session with Jon or one of his colleagues. There you have the email on the screen, as well as you can visit onlinevisas.com. Thanks again.
please tell us if you came from Visa Franchise. We'd love to know that that you watched this show and you found this is where we got the information from, if you wouldn't mind.
Thanks. Yeah. And again, free immigration strategy session. And Jon, really appreciate joining.
Thanks, Patrick. Appreciate you.